In Company versus Country, Michael Robinson explores the boom in foreign investors suing governments and asks, is democracy threatened?
International trade? Boring? Well, if it ever was, it's certainly not now.
Hello everyone, welcome to the protest.
In London and in cities across Europe, protesters, organised by social media, are loudly opposing a proposed trade treaty between Europe and the United States.
If we keep going, we can win. The grassroots can stop this. Thank you.
A really big issue triggering the protests is a right under the proposed treaty for an investor on one side of the Atlantic to sue a government on the other if they say that government's actions damage their commercial interests. In legal jargon, bear with me, it's known as Investor-State Dispute Settlement, or ISDS, and it's already built into thousands of treaties around the world. In this programme, we'll examine ISDS, how it came into being, and why protesters are now saying it poses a threat to democracy.
We've seen case after case of environmental policies being challenged, of nuclear power rollback being challenged, of tobacco control policies being challenged.
Melinda St. Louis is International Campaigns Director for Public Citizen, a large American-based NGO.
Each time we see one of these egregious cases, there's a new group of people who didn't know about it before and are suddenly saying, wait a second, this isn't anything that we thought we signed up for, and it's not appropriate. There's massive opposition to this in Latin America, in South
Australia's legal costs. Under Australian law, that was the end of the matter, but Philip Morris had found another way to attack the plain pack legislation at the same time, through an investor-state dispute settlement, or ISDS, a case that's still ongoing. The basis for Philip Morris's challenge to Australia's plain pack legislation is in a treaty signed in Canberra in 1993 between the governments of Australia and Hong Kong. And it says here on the front page of the treaty, the purpose is the promotion and protection of investments between the two countries. Given all the trouble it's caused, though, the amazing thing about this treaty is it's just 8 pages long. I showed the treaty to Matthew Weiniger, an ISDS specialist and partner at the international law firm Herbert Smith Freehills. So what are the key things in this treaty?
There is a specific protection for intellectual property rights, including copyright, patents, trademarks, industrial designs. That's the critical phrase that's at issue, because what the tobacco companies are saying is that the action of the government has removed their intellectual property rights. They can no longer deploy their brands.
So where does it say that the government has the right to regulate for something like health, like tobacco?
This treaty is dated 1993. So this is the first generation of treaties, if you like. And it doesn't say anywhere specifically that there is a right to regulate in favour of public health.
Advocates of ISDS, like Matthew Weiniger, say it's an effective way for investor-state disputes to be resolved. And a lot better than the way it used to be done.
The Suez Canal, never far from the news in its 87 years of history, hits the headlines like a bombshell when, without a hint of warning, Egypt's Premier, Colonel Nasser, announces that his country is taking it over.
It's 1956, and before long, Britain and France, the joint owners of the canal Nasser had nationalised, were at war with Egypt alongside Israel, trying to win it back. Taylor St. John has studied the history of investor-state disputes.
Gunboat diplomacy persisted into the 20th century. Countries like the UK or France tried every avenue possible to get that property back, and often they were willing to resort to force.
Within days, Port Said reeled under the attack of Anglo-French invasion forces intent on wresting control of the Suez from the Egyptian government.
The investor-state dispute system was the replacement for force and power. Replace the sword in the battlefield with a peaceful legal solution.
ISDS treaties promised companies protection against state actions like nationalisation. Taylor St. John says that's why they were promoted, as a way to encourage developed world companies to invest in the developing world, where governments and courts were often distrusted. The first so-called bilateral investment treaty was signed in 1959. Others soon followed, many with ISDS investor protection mechanisms built in. And before long, Lauger Poulsen of University College London says they were part of the routine business of international diplomacy.
Most investment treaties were signed essentially as diplomatic tokens of goodwill. When presidents or prime ministers went abroad or you received foreign delegations coming to town, then you need something to sign. So you sign a cultural collaboration agreement, you sign sports collaboration agreements, a whole raft of agreements that have no legal or practical implications whatsoever. And often, investment treaties were thrown into as part of that package, as a photo op, something for the press.
Lauger Poulsen says most developing countries didn't understand the potential impact of those photo-op treaties, drafted, of course, by the industrialized nations to protect their investors.
I travelled to Pakistan, to Karachi, to interview the former Attorney General of Pakistan, who's called Makhdoom Ali Khan, who was one of the most knowledgeable experts on international commercial and public law in South Asia. And what he said was in 2001, he received a letter from the law minister at the time saying that Pakistan was being sued by a Swiss investor on the basis of an instrument called a bilateral investment treaty. And the law minister asked his Attorney General, do you have any clue what this means? Have you ever heard of such a thing as a bilateral investment treaty? And the Attorney General was very embarrassed, but he said, I'm sorry, sir, I have to get back to you. So he hung up the phone and he went into Google, and there he pressed, what is a bilateral investment treaty? And that's how he learned about those instruments for the first time.
And he was the Attorney General of Pakistan?
He was the Attorney General, and he was a very capable Attorney General, and he didn't have a clue.
In the 1990s, the newly liberated nations of Eastern Europe were signing up to investment treaties with ISDS, and by the end of the decade, more than 1,500 such treaties were in place globally, mostly unused and forgotten. But then lawyers started realizing their potential. Matthew Weininger's aha moment came at a memorable meeting with a client who had a problem with an East European government.
He presented me with a treaty, the sort of which I'd never seen before. I found it remarkable that it was such a brief document, 5 or 6 pages, but I realised that this was an extremely powerful tool. And from that moment on, whenever I met investors who had similar problems, I said, well, the first thing we need to look at is whether there is a bilateral investment treaty that covers your investment.
OK, so you come across it for the first time, you go, wow, this is pretty powerful stuff. At that time, how much of this business was going on? I mean, how many people here at Herbert Smith were working in this kind of area?
I don't think anybody was. It was really new. I think, looking at what happened around the world, that many lawyers made the same discovery as I did around the same time, because this was the beginning of a wave of claims that started to be brought.
What, lawyers start waking up to the possibilities?
Yes, lawyers started waking up to the possibilities and advising their clients that this is something to look at. And then, as a result, the clients start bringing claims, the awards are published, and then it becomes widely known that these treaties can be used for the benefit of investors.
London is one of the most important centres anywhere in the world for deciding commercial legal disputes. But here at number 70 Fleet Street, just down the road from the traditional courtrooms, a very different kind of court has been expanding rapidly. This, as the sign on the building proclaims, is the International Dispute Resolution Centre, a place where ISDS disputes between companies and countries are increasingly fought out. Professional arbitrators appointed for each case decide disputes at the IDRC. And as Chief Executive Damien Hickman told me on a tour of the building, it's a booming business. In the past 15 years, it's trebled in size. In this arbitration business round the world, how important is 70 Fleet Street where we are now?
It's certainly the biggest international arbitration centre
in the world.
In the world, and the busiest.
Wow, this is a pretty impressive room.
This room has a capacity of 100 people, and sometimes you will have very big parties coming along.
And how long do these cases take?
It could be anything from a day to our longest case we had was 10 years.
10 years?
Which was sitting 3 months every year for 10 years.
I see bookshelves down the side, huge bookshelves. What are they for?
The bundles. A bundle is a set of lever arch files which are full of paper. And an average bundle is 200 lever arch files. We had a case here and we had over 7,000 files in this room alone, and we had to have the floor load tested to take the weight.
Did it pass?
It did indeed, yeah.
And one thing I do notice is there's no seats, as there would be in a normal court, for the public or for people.
National arbitration case, because it is private. There's no sort of public gallery or anything like that. So,
is that a selling point?
I'm sure it is for the parties, yes.
On the way back to his office, Damien let me glimpse an arbitration going on through a glass door panel. It's the closest, I suspect, I'll ever get. So room A10 says arbitration, so it doesn't say who's there.
No, indeed, that's very, very private, this case, and this case has been going on for 3 weeks. So
you know who's there?
I know who the lawyers are, and I know the arbitrators, but I don't know who the parties are.
Even you don't know?
Even I don't know.
Really?
Really, yeah.
Wow. I find that amazing. I mean, you run the place. That's secret.
Very secret, yeah.
Supporters of the ISDS system say that because these tribunals are in private, isolated from the publicity and political pressure found in some national courts, they can be and are fair to both sides. They cite the fact that governments have defeated around 40% of the roughly 600 claims so far known to have been brought against them as evidence of that fairness. But critics say the whole system is biased in investors' favour, not least because only investors are allowed to bring ISDS claims.